Hey! Hi, people. Hi, periods 1, 3, and 5. Welcome to the Supreme Court lecture, starring period 6. Round of applause for period 6. So here we go. Anybody in period 6 want to say something?
Hi, Bonnie.
Hi, Bonnie. Oh, rest in peace. I can't do I don't know how. Huh? To do what? Oh, sorry, I forgot about Ingo v. Vitali. I can't do that. Okay, this lecture is on the Supreme Court. It's a very important lecture, so pay close attention because I wish I could be here to tell you this one, but I can't, and yeah, pay close attention. Here's our Supreme Court right here. This is our newest Judge Gorsuch. We've been doing stuff with this, so you should know who these people are. We are going to watch video clips today about this guy, Clarence Thomas, and anybody else? I don't know. Definitely Clarence Thomas. Okay. All right, let's get started. Grab your fill-in notes. Make sure you're on your fill-in notes. We have said before that the Supreme Court is the only court mentioned in the Constitution. You do not need to memorize articles in this class. I've never had my students do that, and it's never been a problem, so don't worry about what article it is. The Supreme Court is made up of 8 regular judges and 1 Chief Justice. The number of judges is set by Congress. If today they wanted to really help out Trump, they could add 4 judges to the court if they wanted to. They do have that power. It would be incredibly scandalous if they did do that. Do you remember a president one time that wanted to do that? What president wanted to do that? And it was like their only big controversy. They failed. Anybody know? FDR tried to do it. And everybody was like, dude, you're trying to make yourself like king of America. You shouldn't do that. And he had to back off. Okay, how does someone become Chief Justice? Here's the answer. When the Chief Justice retires or dies, so today John Roberts, if he retires or dies, the president can appoint somebody already on the court that they like a lot, like you're the new Chief Justice. Then they would still have to pick a new person, like a 9th judge. You follow me? Or they can pick a brand new person and make them new to the court and Chief Justice of the court. The last one in my life was John Roberts, and he was brand new, not a part of the court. He was from the circuit court, I think. But one of the guys, Rehnquist, who we talked about today in one of the court cases, is Oregon v. Smith. That guy was already on the court, and then the president liked his decision so much they made him Chief Justice. Okay. What are the 3 things a judge can do? They have the power of judicial review. By now in this class, you better know what that means, that they can decide whether a law is constitutional or not. They have the power to interpret broadly worded laws and the Constitution. For instance, in the Constitution it says, Second Amendment, you have a right to bear arms. It also says, with a very well-regulated militia. What does the phrase well-regulated mean? That's an example of you need a judge to sort that out and decide what does that mean. And then they have the power to overrule themselves and change their own minds, sometimes 80 years later, like Brown v. Board overturning Plessy v. Ferguson. Okay, we have learned before about jurisdiction. Do you remember what jurisdiction means? Who has the right to hear the case? So the only time, little trivia, the only time that a case goes directly to the Supreme Court is if it involves states and ambassadors. That's the only time it goes directly to the Supreme Court. Nothing else goes straight there. When do they have appeal jurisdiction? Whenever a case is coming from the Court of Appeals, like you learned in the pyramid. Or, this is brand new information that nobody knows probably. You remember we drew our 2 pyramids? If a case gets to the top of the other pyramid, it can go to the Supreme Court after it reaches. So the state pyramid, if a case gets to the top of the state pyramid, it can go to the Supreme Court. Obviously, between these 2, do they get more cases involving states and ambassadors or more cases that are appealed? Which happens more frequently? The appeal one. So look at the bold, there's a bold note. That means it's been on a test before. Cases that are appealed are far more common than states and ambassador type cases. Recording again. How do cases reach the Supreme Court? They're in control of what cases come to them. They control their own docket. Was docket a vocab word? It was. Docket is like things, a calendar, things that they accept, cases they accept. There are thousands of requests made. Thousands of requests made. You guys always watch that movie where the guy is in prison, like on death row, and it's like, I'm going to become a lawyer and take my case to the Supreme Court. Like, everybody wants to take their case to the Supreme Court. But only about 80 to 100 are accepted every year. So obviously lots of broken hearts, lots of cases that don't get to the Supreme Court. They follow the rule of 4, and I feel like we know this, but you got 9 judges, 4 of them have to want to hear a case for the case to be accepted. That also might mean the ruling could be 4 to 5 and they lose, but at least it allows an opportunity for a case to be heard. Why might they deny a decision? The case lacks a federal issue. A party lacks standing, like someone is suing who shouldn't really be involved. Or, here's a big one, the court already agrees with how the lower court ruled. If they refuse to take a case, then the lower court's decision is what happens. So let's say like there's the gay couple that wanted the wedding cake. Does that ring a bell?
Yeah.
Let's say the case is appealed to the Supreme Court and they're like, no, we agree with what the circuit court did. They just say, no, we don't want to hear it. And what the circuit court did becomes kind of like law in a way. Like that's the new like stare decisis. Or a lot of times like with gay marriage, they just didn't want to make a decision because it was too controversial. They called it a hot potato. The court does not want to touch that issue, so they just stay away from it. And finally, they accepted a gay marriage case like a few years ago, but they wouldn't do it for years and years and years. And like abortion cases, they don't want to hear them right now because, you know, they feel like they've already ruled on it and they don't want to have to make a new ruling too controversial. Okay, vocab time, important phrase that this will show up on like an FRQ on the Big Papa test, and like if you're not prepared, you might be caught off guard. When I am at the circuit court level and I like, you know, they found me guilty or whatever, and I'm like, oh my gosh, I want the Supreme Court to rule. What I do is I file a petition called a writ of certiorari. Everyone say certiorari. It's a weird Latin word. It means to be made certain. And I'm basically, what is a writ of certiorari? It's a letter to the Supreme Court saying, please hear my case. And then this is like the whole rule of 4, and they decide if they're going to hear your case. When they accept a case, they decide if they're going to rule on the case using just the information they have, or they might, this is what you probably picture more often, they call down the lawyers to do oral arguments, like actually debate and like discuss. It's pretty quick though, I don't know what it is, a couple hours or something. That's it. They come down and they do a 2-hour thing. Oh my gosh, you guys are so childish. I know why you're laughing, and grow up. Okay. The rest of you are figuring it out. Okay. Okay. Cases, at least period 1 through 5 are paying attention now. Cases that are decided where they don't need any more information are decided on a per curiam basis. That means like we made our decision and we didn't have to call you down to give additional arguments. I don't feel like this comes up too much for you to know, but you really need to know writ of certiorari and realize that it's just somebody appealing their case to the Supreme Court. Okay, here we go. Oh, that was one side. The Supreme Court, they show up to work on the first Monday in October. So they have a schedule kind of like yours. They have like the summers off. They show up the first Monday in October and they stay there till the end of June. They must have 6 people. This is a use of the word quorum. They require 6 people in order to hear a case. Before these types of arguments begin, the justices read letters from the attorney. They also read, this is a, we have learned this before, right, in the interest group section?
Yeah.
So, like, also interest groups, they write letters. Let's say the case is about guns, then the NRA writes letters, and maybe Florida students that survive, they write letters. They're a friend of the court trying to get involved to get their opinion heard because it relates to the outcome of the case. Raise your hand if you remember amicus curiae briefs. Uh-oh. Oh, a little bit better. Okay. It's do I need to say again? If you are shaky on it, you should write down the definition. It's letters that interest groups write to get involved in a court case so that their opinion is heard. Look how short it is. They only hear 30-minute arguments from each side. That's it. Just arguments. I'm not going to say the other thing. Verbal.
Define verbal.
Of or pertaining to the use of verbs.
How do you do argument?
Ramos. All right. Okay, look. So let's say there's a case. If I'm a justice, I'm gonna read up about the case. We're gonna pick a day on the docket. Okay, your appointment is November 11th. The two sides come down. They get 30 minutes to explain their side of the story. It's not your traditional case. I went to a case in Riverside about a lady that beat up her man at the gas station. It lasted 3 days. Okay, these people get 30 minutes to make the case of their life. And then on Friday, they sit down in a conference with just the judges and they discuss like their opinions and maybe try to persuade each other a little bit. Of course, we know they just need a simple majority. In a case of a tie, this is a big one that happens in real life. Like before Gorsuch was appointed, for a whole year, they just had 8 judges. So then there was lots of ties. And what happens is the decision goes down the pyramid to the prior level, and they're going to do whatever the prior level said. You with me? So if it's 4-4 here, they're going to look down at the middle of the pyramid and say, well, they said guilty, or they said unconstitutional, and that's it. That's what they'll do. Until the next year when they have 9 judges, and maybe they'll hear the case again. That happened, very controversial last year. This is dorky, but it involves teachers. Anybody with a union. The Supreme Court might get rid of unions this year. Last year they had a chance, and the ruling was 4-4, and so like unions survived a little bit longer. But this year the court is deciding, is it okay for unions to take money out of your check without your permission? And if they rule the way that I think they will, they're going to rule that like unions don't have a right to take money out of your check. You have to say take it out, and that's going to kill like a lot of unions because people will just not say take it out. And anyway, keep an eye on that one for this summer. That'll be one of the bigger decisions they're going to make. All right, topic, written opinions. What are the different types of opinions? There's unanimous. Class, what does unanimous mean? Everybody agrees. 9-0. Like Brown v. Board was such a powerful opinion because it was 9-0. Opinions that are unanimous have more weight. Like Americans don't question it. Like you can't sit there in Mississippi and be like against school integration. You understand? And when it's 9-0, it feels like, dang, I'm the racist one. You know what I mean? Like if you're still against it, like, but the court's 9-0. Where 5-4 is more like, oh, it barely passed. There is if a judge makes, they all write these like essays. For every opinion, they write an essay. That's what their opinion is. We're talking like 10, 40 pages, whatever. Like long. Some of them are interesting to read. Some of them are really boring. It's like college. And like sometimes they agree, but they agree for different reasons. The Chief Justice, I'm sure this will appear on a slide somewhere. The Chief Justice reads the essays and decides, I really like the way that I really like Ruth's work here. We're going to use her essay as the go-to opinion. Like this will be the cover. This will be the one that you look at. This is where you guys screw up sometimes and you say Hugo Black. Because Black wrote the majority opinion, but he wasn't the Chief Justice. You understand? And that's where kids get confused. And then there is the dissenting opinions. What does it mean to dissent? To disagree. And so even the losers or whatever, even the side that doesn't win, the judges are writing opinions. And then there is concurring, maybe the most confusing. Concurring means I agree with, let's say it's a 5-4 decision. I agree with these other judges, but it's for different reasons. Like I don't know. Try to think. I don't know. I'm trying to think of one that makes sense. Like the peyote one, they said like, oh, religious practices don't represent like a good reason to do an illegal thing. And then maybe a judge struck it down just because like for some other reason they're against the use of like that for a different reason than the other judges. They agree, but they didn't get there the same way. That's what a concurring opinion is. That wasn't the greatest example, but I couldn't think of anything. This is kind of like what I just said. If the Chief Justice voted with the majority, he assigns somebody to write the opinion. I guess this is a little more clear than what I said. If the Chief Justice is not in the, if he's not in the majority, then that means he's in the minority, and that means he shouldn't be picking the opinion if he disagreed with the outcome. You know what I mean? So instead, they're going to go with the judge that's been on the court the longest to pick. That's pretty trivial. Like, I don't think you need to know that. It's just fun APGov fact. Do I need to say it again?
I can't read it.
You can't read it. It's a little bit wonky looking. Okay, assigning the opinion is a key power of the Chief Justice. The majority opinion writer has to be very careful the way they write their essay so they don't piss off the other people that are in the majority. You don't want to be like, you know, see, all drugs are bad, and then somebody in the majority is like, hey, I don't agree with, I'm switching sides. You know, see, it's very political. You gotta like be inclusive. So the person that writes the majority needs to write it in a smart way, an intelligent way, so the other judges like what they hear and they don't jump ship and change their vote. Because it's not, I don't know if you guys realize the judges aren't just voting yes and no. In the opinion of the paper, this is their chance to really like explain why they made the decision and like change other policy too. Like in the gay marriage case, if they wanted to make polygamy legal at that moment, they could have done that too. Like they have wide-ranging power, but they need all 5 justices on board or more. You get what I mean? Like they have a lot of leeway to make all kinds of changes. Why do they write these opinions? Because they need to show the public why they made those decisions. A lot of you guys quote the judges, right, when you present your court case. This is where your quotes are coming from. They're coming from the opinion papers. And then they establish precedents to be used so that some judge someday can use their case as stare decisis. And if there's some other cake shop owner that's not letting people get a cake, then like they'll say, well, look at that other case, you know, and they already have established a precedent. Okay, the Supreme Court is the highest court in the land, but it is possible to get around Supreme Court decisions. Think to yourself, how could you get around Supreme Court? What's the most powerful way to do it? Changing the Constitution. All right, changing the Constitution. That's one way to get around the Supreme Court decision. Let's say they ban gay marriage at the Supreme Court level, and you're like, what the heck? That seems crazy. Then then change the Constitution and say gay people can get married. That's like a surefire way to do it. Really hard to do, obviously. I don't care too much about the second bullet. In the past, we've seen presidents not comply with Supreme Court decisions. It's pretty rare, but Andrew Jackson did it, right, with the Native American removal thing. Did you learn that in your U.S. history class? He just didn't do the thing they said. I feel like that's pretty impeachable if you did that, but it has been done before. And then sometimes state and local governments simply try not to listen. Like desegregation, you think it stopped in Brown v. Board, but it took like many, many more years because they refused to do it. Or how about that lady that wouldn't give out the marriage licenses, you know, and she went to jail and stuff. Like, people refused to implement it. Many schools kept on praying, even though they were told they weren't supposed to. And they all had to be sued, like, on an individual basis. So it does take a while. Is that the end of our notes?
Yeah.
In 3 sentences, explain to me, why do we need a Supreme Court? Why is it necessary to have a Supreme Court?